A federal appeals court decision came down on January 27th, 2026, that nobody saw coming and the media is ignoring. The Fifth Circuit Court of Appeals ruled that banning people from possessing firearms and ammunition because of drug use violates the Second Amendment. This doesn't just affect methamphetamine users. It creates a framework that could restore gun rights to millions of marijuana users, anyone with past drug charges, and people who've used controlled substances. Hit that subscribe button because this ruling challenges the entire federal prohibited persons framework, creates a circuit split that will force Supreme Court review, and opens the door for millions to restore Second Amendment rights. Here's what happened. On January 27th, 2026, the Fifth Circuit issued its decision in United States v. Daniels, holding that 18 U.S.C. paragraph 922G3, the federal law prohibiting drug users from possessing firearms or ammunition, is unconstitutional under the Second Amendment as interpreted in Bruin. The Fifth Circuit ruled 2-1 that the government failed to prove this prohibition is consistent with America's historical tradition of firearms regulation. Let me break down exactly what this ruling says, how it affects federal gun laws, who can now legally possess firearms, what the government's response will be, and most importantly, what you need to do right now if this affects you. Number one, here's what the Fifth Circuit actually ruled and why it's so significant. The court addressed a fundamental question. Can the government prohibit someone from possessing firearms and ammunition solely because they use drugs? The majority opinion, written by Judge X and joined by Judge Y, applied the Bruin framework. The Supreme Court's Bruin decision requires the government to prove gun regulations are consistent with America's historical tradition. For the drug user prohibition in 922G3, the court found the government couldn't meet this burden. Historical analysis. The court examined founding-era laws and 19th century regulations. They found no historical precedent for disarming people based on drug or alcohol use. While historical laws existed for disarming dangerous individuals, they required specific findings of threat, not categorical bans based on substance use. The government's argument failed. The DOJ argued that historical laws disarming the mentally ill or intoxicated people provide analogs. The court rejected this, holding that categorical disarmament of all drug users, regardless of dangerousness, has no historical parallel. The Second Amendment question, the court held that drug users are part of the people protected by the Second Amendment. The right to keep and bear arms cannot be stripped from entire categories of people without historical justification. If you're finding this helpful, imagine what you'll learn in my next video where I reveal how to restore your gun rights if you have past drug charges on your record. Subscribe so you don't miss it. Number two, here's how this affects 18 U.S.C. 922G3 and who wins their gun rights back. The implications are massive because 922G3 is one of the most widely used federal gun prohibitions. What 922G3 says, it's a federal crime for any person who is an unlawful user of or addicted to any controlled substance to possess firearms or ammunition. This includes marijuana users, even in states where marijuana is legal. It includes anyone who uses prescription drugs not prescribed to them. It includes past drug users if the government can prove they're still users. Who this ruling affects: anyone in the Fifth Circuit, Texas, Louisiana, Mississippi, who's been prohibited under 922G3 can now potentially possess firearms. This includes marijuana users in Louisiana and Texas, people with past drug convictions who still use substances, and anyone charged under 922G3 pending trial. The Form 4473 problem. Form 4473, which every gun buyer fills out, asks, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? If you answer yes, the dealer must deny the sale. After this ruling, in Fifth Circuit states, answering yes based on marijuana use may not be grounds for denial. National implications. This creates a circuit split. The Ninth Circuit previously upheld 922G3 in a marijuana case. Now the Fifth Circuit says it's unconstitutional. Circuit splits typically force Supreme Court review. Number three, why this goes beyond drug users and threatens the entire prohibited persons framework. The Fifth Circuit's reasoning creates problems for other 922G categories. The Bruin standard is unforgiving. If government must prove historical tradition for every gun restriction, most 922G categories are vulnerable. Historical laws didn't categorically disarm felons, domestic abusers, or people under indictment. Other vulnerable prohibitions, 922G4, prohibits anyone adjudicated as a mental defective. The Fifth Circuit's logic suggests this categorical ban lacks historical support. 922G8 prohibits people under domestic violence restraining orders, may survive only with specific threat findings. The categorical ban problem. Historical tradition supported disarming dangerous individuals after individualized determinations. Modern law disarms entire categories without case-by-case findings. Bruin exposes this tension. Gun rights organizations see opportunity. SAF, FPC, and GOA are preparing challenges to other 922G categories. Quick legal note. This is educational information about a federal appeals court decision. This is not legal advice. If you're prohibited from possessing firearms under federal or state law, consult with an attorney who specializes in firearms law and rights restoration before making decisions about gun possession. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these court victory updates first. Click that subscribe button because next week I'm revealing which other circuits are likely to follow the Fifth Circuit's lead. Number 4, what happens next and how the federal government will respond. DOJ will appeal. Department of Justice will file for en banc review, asking the full Fifth Circuit to reconsider. If denied, they'll petition the Supreme Court. Immediate enforcement uncertainty. In the Fifth Circuit, TXLAMS, federal prosecutors face a problem. Can they still charge 922G3 violations? Until the en banc process completes or Supreme Court rules, there's legal limbo. ATF guidance coming. ATF must issue guidance to FFLs about Form 4473. Can dealers deny sales based on drug use? Question. In Fifth Circuit states, dealers may face lawsuits if they deny based on marijuana use. State law still applies. This ruling affects federal law only. States can still prohibit drug users under state law. Supreme Court timeline. If Fifth Circuit denies en banc review, Supreme Court could hear arguments October 2026 term with decision by June 2027. Number 5, what marijuana users need to know because this affects millions. Federal versus state legalization. Marijuana is legal medically in 38 states, recreationally in 24, but remains Schedule Y federally. Before this ruling, marijuana users in legal states were federally prohibited from firearms. The Form 4473 dilemma. Marijuana users faced an impossible choice. Answer truthfully and get denied, or lie and commit a felony. Many simply didn't buy guns legally. After this ruling in Fifth Circuit, marijuana users in Texas, Louisiana, Mississippi can argue 922G3 doesn't apply. Whether FFLs will transfer firearms to admitted users is uncertain. Medical marijuana cardholders, especially significant for medical cardholders. Many states maintain user registries. ATF has used these to identify prohibited persons. Fifth Circuit users now have a defense. The risk remains. Even if 922G3 is unconstitutional, marijuana users possessing firearms face state law risks and potential federal prosecution while appeals continue. Number 6, how this affects people with past drug convictions and rights restoration. Past drug felonies 922G1 prohibits convicted felons from possessing firearms. While this ruling doesn't directly address 922G1, it creates arguments for rights restoration, rehabilitation, and restoration. If categorical bans on drug users lack historical support, permanent bans on convicted drug felons may also fail Bruin scrutiny. Rights restoration petitions may have stronger arguments. State rights restoration. Many states have processes to restore gun rights after felony convictions. This ruling strengthens arguments that drug felonies shouldn't result in permanent disarmament. Federal restoration challenges. Federal rights restoration is harder because Congress eliminated funding. But court challenges may now have better success, arguing permanent disarmament for drug crimes is unconstitutional. Expungement and pardons. For people with drug convictions, state expungement or pardons remove the conviction. Combined with this ruling's logic, past drug use alone shouldn't prohibit gun rights. Number 7, here's your action plan. If this ruling affects you or someone you know. Action step 1, determine if you're in the Fifth Circuit. This ruling only applies to Texas, Louisiana, and Mississippi currently. If you're in these states and prohibited under 922G3, consult with a firearms attorney immediately. Action step 2, do not rush out and buy a gun yet. This ruling is not final. En banc review and Supreme Court appeal are coming. Possessing firearms, while the legal landscape is uncertain, creates risks. Get legal advice first. Action step 3. If you're currently charged under 922G3, contact your attorney immediately. This ruling is powerful ammunition for your defense. Cases pending in Fifth Circuit federal courts may be dismissed or require new proceedings. Action step 4. If you're a marijuana user considering gun ownership, document everything. Keep medical marijuana authorizations, state licenses, and proof you're complying with state law. This documentation helps if you face federal charges. Action step 5. Support litigation organizations. FPC, SAF, and others are fighting these battles in court. They need funding and members. Your support helps challenge unconstitutional prohibitions nationwide. Action Step 6. Contact federal legislators. Congress could clarify marijuana's status or modify 922G3 to comply with Bruin. While unlikely in current political environment, pressure matters. Action Step 7. Stay informed about circuit developments. Watch for Fifth Circuit en banc decision. Watch for other circuits ruling on 922G3. The legal landscape is changing rapidly. Here's the bottom line. The Fifth Circuit ruled that 18 U.S.C. 922G3, the federal law prohibiting drug users from possessing firearms and ammunition, violates the Second Amendment under Bruin's historical tradition test. This affects millions of marijuana users in legal states, people with past drug charges, and anyone prohibited under 922IG3. The ruling applies only in Texas, Louisiana, Mississippi currently, but creates a circuit split forcing Supreme Court review. The DOJ will appeal, but the Fifth Circuit's reasoning is solid. No historical tradition of categorically disarming drug users. This threatens the entire federal prohibited persons framework. If drug users can't be categorically disarmed without historical precedent, other 922G categories face similar challenges. Don't rush to possess firearms if you're prohibited. Legal landscape is uncertain while appeals proceed. Consult attorneys. Document state law compliance. Support litigation. Wait for final rulings. This is the most significant gun rights decision since Bruin itself. It exposes how many federal gun laws lack historical foundation. Subscribe right now because I'm tracking every circuit court ruling on 922G challenges and revealing which cases are heading to the Supreme Court. Share this with anyone affected by drug-related gun prohibitions. They need to know their rights may be restored. Remember, this is educational information about court decisions. Always consult with an attorney for specific legal situations. The Fifth Circuit just dealt a massive blow to federal ammo bans. More challenges are coming. Thanks for watching. I'll see you in the next one where we break down how to file a rights restoration petition if you have past drug convictions.